Now,
Now,
hello, my name is Daniel Abraham. I'm an attorney in Brooklyn that handles copyright and trademark cases. I am a former artist. Most of my clients are artists, and I deal with copyright issues to a great extent. I am here with my friend Mark Monlux, who is an illustrator who will tell you about himself in a moment. And we are going our Law and the Artist.
hi, my name is Mark Monlux. I'm a professional illustrator inside Tacoma, Washington, and Daniel and I are Law and Artists. Today's topic is going to be attorney's fees.
Before we get into that, let me read a brief disclaimer. Law and Artist discusses general legal principles of law in response to issues of concern to the illustration community. Nothing should be construed to be a substitute for advice of counsel regarding the specific facts and circumstances of an individual case. Laws and their interpretation differ from jurisdiction to jurisdiction. Legal advice addressing a specific situation should be sought from an attorney duly licensed in the appropriate jurisdiction.
Daniel, this is a topic we've been wanting to talk about for a long time.
Yes, well, it's a very important topic because attorney's fees can be extremely expensive, and the problem is artists, when I've been involved with artist cases, which is most of my legal practice time, they're very frustrated by the slow process of the law. And the law, of course, this contrives to try and be fair, which means that it moves slower than a drunken slug. It takes forever, absolutely forever, to get from filing a complaint to actually getting to a court case, to actually getting the court case adjudicated. And this is a serious problem. So as this happens, of course, attorney time piles up, and with attorney time comes attorney's fees. Now, it's very important to remember that attorney's fees are in some ways, because they can be so expensive, they can be more important than the actual damages. Most infringers are willing to pay their own attorney to defend themselves against you, but they're not necessarily willing to pay your attorney for you to fight them. And so if there's a prospect of attorney's fees coming up so that they will have to pay those attorney's fees as well as their own, they aren't going to want to do that, and they're much more willing, therefore, to settle a case.
Now, one of the things we're going to be talking about is a recent court case between Kirtsaeng and John Wiley and Sons, a book publisher. Kirtsaeng got this bright idea of purchasing books overseas and then importing them into the U.S. and then reselling them at a much lower cost.
Yes, he was taking advantage of the difference in income and the difference in price between, I believe it was Thailand, I could be wrong about that, but it was somewhere in Southeast Asia. He was from Southeast Asia. He said, okay, they're charging $200 for a textbook in the U.S. I can get the same textbook for much less back home. I'm going to buy up a bunch of textbooks, bring them in, and I'm going to make a profit on the difference in price. Brilliant idea. Wiley didn't like this because, of course, he was taking advantage of this price differential that they were using for themselves, and they sued him. He ended up winning. Now, this is an example of what they call the first sale doctrine. Normally, the first sale means that you buy something, you own it. If you buy a book, you can then resell the book, at a stoop sale to a bookseller. You can do whatever you want with it. But there is also a provision in the copyright law which prevents which prevents people from importing something from one venue to another if they do not have permission to do so. Kirtsaeng took advantage of this. The Supreme Court found in his favor. Then came the issue of attorney's fees, and the court came down on both sides. They said, well, he prevailed, but he shouldn't get the fees because the other side also had a reasonable argument.
Which is really interesting because here's a court case. The poor guy, he's stuck with his own attorney fees, which probably are, like you said, fairly tremendous.
He claimed $2 million.
Oh my God, $2 million.
$2 million. It's mind-boggling, isn't it?
It is. But in most cases, you can use attorney's fees if you are in the right to pretty much leverage a settlement before you even start going to court. It's a very powerful tactic.
I absolutely agree. Unfortunately, we have no time for this, but perhaps in another session, I can tell a funny yet sad story where if the artist had actually registered in time to claim attorney's fees, we would have gotten an early settlement for a large sum of money instead of being in court for a year and getting a much smaller sum of money.
Well, that's all the time we have.
I mean,
well, that's all the time we have this week on Law and Artist. We're trying to keep these videos nice and short. Daniel and I haven't quite decided what our next topic will be, but you'll find out in the next episode. Thank you guys for watching.
Indeed. Thank you very much.
Thank you, Daniel.